The term privity means relation between the two parties that recognized by law, and contract means an agreement enforceable by law. Privity of contract is a doctrine of the common law principle. It means a contract does not create any legal right nor confer any obligation upon the third party or stranger to the contract. In short, it prevents a person who is not a party to the contract to enforce. Before the emergence of this very doctrine, the English court allowed the third party to enforce the contract, specifically in the case of the near relatives of the promisee. The doctrine of privity of contract developed along with the doctrine of consideration. The main dictum lies behind the doctrine of privity of contract is that the stranger or the third party who is not a party to the contract cannot claim or demand against the party to the contract even though the contract has been done for his benefits. The doctrine firstly developed in the decision of Twaddle versus Atkinson, but in the case of Dunlop Pneumatic Tire Company Limited versus Selfridge and Company Limited, the doctrine has been dealt with the great analysis and developed further. In this case, Dunlop, the tire manufacturer, had entered into an agreement with the dealer Dew and Company not to sell below the recommended retail price. It was further agreed that dealer to get agreed with the retailer. If sold below the retail price, £5 have to be paid as damage per tire to the Dunlop company. The retailer Selfridge sold below the retail price. Dunlop filed a case against the Selfridge, claimed damage. It was finally settled by the House of Lords that there was no contractual relationship between Dunlop and Selfridge, nor there was any agency relationship between Dew and Selfridge. So, the claim of the Dunlop company does not stand. There is a difference in the English law and the Indian law, is that in Indian law, a person who is a stranger to the consideration can claim, but not so in the case of the English law. Essential feature of privity of contract. 1. A contract has been entered between two parties. 2. Both the parties are competent to enter into the contract under law. 3. One of the party to the contract had breached the term of contract. 4. Other party to the contract can sue. That is, only the parties between whom the contract has been made can sue each other. Let us now discuss the exception of this very doctrine. 1. Beneficiary of the trust. A contract has been entered between the two parties for the benefit of the third individual. In such case, the third individual or party can enforce his right against the other. In case of a trust, the truster has entered into an agreement creating a trust with the trustee for the benefit of the beneficiary. Here, beneficiary is the third individual or party but can enforce the right against the trustee. 2. Act of acknowledgement. In a contract, either of the two parties acted in such a manner that acknowledges the right of the third party. Then the third party may enforce the right against the party to the contract. 3. Maintenance or marriage under the family arrangement. This exception is used to safeguard the interest of the family member. Say, A distributed a property among his two sons B and C, and A put a condition that B and C will give all the golds and other valuables to his daughter C upon the death of A. If B and C or either of them breaches the contract, then C can sue against B or C or both. 4. Agency. If A is the agent of B and enter into an agreement with C, then under section 185 of the Contract Act, A or B may sue C.